including the last several hundred of them, because I'm negative.
Suppose that we are selecting state, this is a select list.
Yes.
1,47,000 candidates have taken place.
Correct.
This list mentioned the name of all those persons.
Yes.
And the marks they have been.
Yes. Yes.
And then it says in the end,
Yes.
anybody who has got more than 100 marks not to be selected.
If it had done all of that, it would be different. Nothing of that sort. This is a reverse question. This is exactly the entirety of it's not even, it calls itself, it calls itself at the top, combined merit list for assistant teacher. And the very, I think it's between third line. Serial number, roll number, name, category.
No, then it says the rank.
And then rank is given the mark. So the last column is rank. Now, just the second page.
Rank is also in serial.
Yes, it's serial. That's just a simplicity rank list without going into eligibility, fitness, nothing else. Just a simple. So you need the first page and the last page.
This is how it is.
It is. So once you clarify that.
I must mention something very important. The document doesn't mention what are the further steps to be taken, but the appointment letters specifically note that there is a counseling and then there is a verification. So unless verification happens, and when they are given the letters of appointment, the appointments can't be made only on the basis of this rank list. This is something that I just, because when I put that, I apparently, there is a rank list in the order of merit, you would probably get appointed in that matter. But that's not so. That's not a conclusive thing for the appointment.
It's like somebody being selected, the subject being unfit.
I think those five sheets were listed out. You have to verify that. That is the next step. This is only to show that you've got a chin above the. That's all. In fact, the last page of the entire list. Marks go up to -20. They go up to -20 simply because you have to ensure that everybody, one particular rank, is transparent here. That's the only reason it is done. So now,
The difference between the serial number and the rank. The same serial number and the same.
it will amount to the same. It will amount to the same.
Rank to depend upon the marks obtained.
Yes, yes. What this serial number is only for showing in the list that we start from 1 and move downward. Ranks is the last column to show that as per the marks.
So it is not as per the marks. Just see.
It's total marks, second last
That's
column.
for the marks.
It's decreasing. It's starting from 1 and moving down.
That's for the marks.
No. Second class.
The value should be right. उसके बाद जो नंबर ये
have taken this opportunity to file an impeachment application in this matter before your lordship to say, hang on, I am going to get that on the bus. Now, therefore, lots of tailoring will start happening now because they want you to dilute the Devesh Sharma judgment even further than what initially happened. Your lordship's notes in fact a clarification back then that normally judgments are prospective. But all these arguments on equity were taken there. After the arguments were taken, your lordship said, look, we're making it very clear. The Devesh Sharma judgment is the command. It's succeeded, obviously get the relief. But unfortunately, in this case, as far as those conditions are concerned, your lordship clarified, no, we're making it prospective in nature. But the safeguard to be provided to balance, because I think a lot of the argument went on equities, talking only about the equities of the male candidates in isolation, forgetting that we exist. Like I said, 1 lakh of those candidates who required the other candidates, fully eligible, who have succeeded. And the government makes a statement before the High Court in the interim judgment saying there are enough and more DNA candidates to take care of all vehicles. So there are enough and more of us to hold this, don't have to worry about the students not being taught, etc.
They say even if all of you are given appointment, let's say today,
Yes.
even then there will be vacancies.
That's not correct. That's not correct. And I'm going by the government statement. Your lordships, if your lordship want to see right away, it's page 45, interim judgment. The state submission is para 28. I'm using the paper book in Naveen Kumar. So, item A, page 45, para 28. This is the state submissions. In fairness, after this submission, they shouldn't have filed the recently. Just in page 20, para 28, Mr. So-and-so, the additional article submits and since at the time of advertisement, the rules 2019 prescribe the qualification of BEd as eligible qualification. Therefore, candidates having such qualification have been allowed to participate in postal selection. However, he submits that the appointment to these candidates has been made pursuant to the interim order dated 29/8/2023. Please note that Devesh is 11/8/2023. The state stand is that the appointments are made under the protection of this court's order dated 29/8/2023. So it's after the cutoff date. Very something they have made. Passed by the Honorable Supreme Court in the matter of Harishankar and others of the state of Chhattisgarh, which have been made subject to outcome of this petition. And therefore, the candidates cannot claim right over the post. Their rights are subjudice to subject to the decision of this petition. He further submits a sufficient number of candidates having the qualification of DNN are available to the state. This is the state stand. So there are sufficient number of hours. So the equity there is also in our favor. That we exist and today we are unemployed. We have not been given these jobs which are due to us in law.
They were saying Karuna. Your brother's keeper, that's what they're saying.
The brothers have been at war like Cain and Abel for long enough. And we shouldn't be. Heaven knows where we'll go after this. Just a few additional facts on Hindu. So first, Bihar, West Bengal, Punjab, and Uttarakhand are cases where this had happened. I'm giving this to your lordship to start the other side. To show what the position is with all the states. Because in Devesh, all the states. Because in Devesh Sharma, all the states are concerned, not only Rajasthan. Let's see this. So Rajasthan is the first case, whether the High Court judgment, the final column we have given that the decision was affirmed in Devesh Sharma, review petitions were dismissed. But the second last column is critical, which is BEd appointment after Devesh Sharma. In Rajasthan, it's no, but Bihar, Chhattisgarh, West Bengal, and Uttarakhand is yes. Therefore, your clarification judgment and yours very clearly on courts in all these cases.
What is this? Yes, yes.
I beg your pardon.
Chhattisgarh Uttarakhand is yes for what?
For appointments after Devesh Sharma.
After the election.
So after 11th August, where appointments have taken place and your clarification level makes it clear, if appointments have taken place after that, you are not protected. The other category which is not protected was those who had been appointed prior to Devesh Sharma, but under protection of some court order. But you also use the words by them, petitions being filed by them. And the argument was taken and successfully by them in the Madhya Pradesh High Court that by them means only our petitions. Now we obviously had no cause to challenge it, but I've argued that already before your lordships, and your lordships have not interfered. That is serial number 9. You see, serial number 9 was that application that I argued before your lordship. So in Madhya Pradesh, where I said please modify those words by them, that you are not inclined to. So this shows you a picture that not only in Chhattisgarh, but also in everywhere it said yes. That's Bihar, Chhattisgarh, West Bengal, Uttarakhand, these 4 states. You will have tailoring to do. In all these other states, we are the only ones left. In all these other states, the BEd have been cast out and the DEd have been completely in compliance. This is the only state that's left. So please don't carve an exception for them, because otherwise all of these will come back and then start unscrambling their again. Now, one more. In Uttarakhand, SLP was filed against the High Court judgment, which is in our favor, and there's a judgment of a coordinate bench which is dismissed the SLP. This refer to them. You want to see the order? We can simply apply it. It just applies Devesh Sharma and dismiss it. This is the 8th of it. This is in fact coincidentally on the same day as the clarification order of your lordship. This is the judgment is 6 December 23, against which this after Devesh Sharma. Afterward, Devesh Sharma is applied. High Court judgment in our favor. This is identical to our circumstance. And
Uttarakhand High Court also said you're not.
they're not eligible. They are not.
When they came here, it was this.
It is SLP. Uttarakhand. So identical, same thing. The impugn order makes reference to this in fact. The impugn order of the Chhattisgarh High Court makes reference to this.
They are saying, Chhattisgarh is a slightly different place.
That
There is a
argument.
problem there.
Across the land.
One of which book
They don't. That's other one.
that's right, own area.
Yeah.
That when people are not willing to go and teach. They are the one who are taking the risk and going saying that हमको वही दे दो.
So 1 lakh of the best of us peer candidates have cast our hats in the ring to show our qualifications. We are all there to take care of these poor Chhattisgarh. Now this is an argument that won't cut away with that won't cut away. There's no bridge course. After we're all from the same state. It's not like we're different states. But there are enough of us. The state makes it clear there's enough of us. 1.5 lakh have taken.
Enough means you are more than 57,000.
Yes, we are 1 lakh. We are fully 1 lakh. 27,000 lords are the vacancies which your lordship were shown in December 23. December 23 is the next phase after our process is complete. Our process is 6,000. So in our process of 6,000, in any case, almost 12 times that or more. There are enough and more of us. So that's the state is absolutely right in saying there are enough and more of us. So the question is, if you're arguing equity, where is the equity here? The cutoff date is not reviewed. Where is the equity? And this court is already dealt the same law as far as Uttarakhand is concerned. Should you lordship be taking a different stand? But just one more thing. Just on the dates, and I think that's a little
Yes.
yes.
You're on the
Yes.
coordinate bench had admitted them for the High Court to give go ahead. Goes ahead and the appointment letters are issued in their favor. They are
So I want to come to that immediately.
right now they are teachers.
Yes.
What teaching?
Yes. There are, but there will be better teachers teaching, because we have to come to the pedagogy without the need of a bridge course, which has still not been brought in for that stage. So let me just answer that. The dates are a little involved. 30th May 2023 is the first filed by us. Page 510 of this, your Lordship will find a preface. Because I think there was an argument made that we can challenge the second preface, query challenges the rule, that's on page 510. So that's the first of the reads. On 11th August 23, the judgment in Devesh comes. We have filed an application before the High Court asking for interim orders. On 21st of August 23, this is relevant. 21st August 23, the High Court grants us the interim relief relying on the wish. As a result of which, the BEd are not permitted to be appointed. That's at page 584. 584 of the same volume.
All right.
At page 586, I'll just read one sentence. Learned counsel for petitioners submit that earlier only BEd candidates were allowed for appointment of the post of assistant teacher, but by NCTE notification dated so and so, BEd at par has been included. But Honorable Supreme Court in very recent Kumar's SLP.
Yes, I
Yes, 584. This is an order of 21st August 2023. And 586. Second line. But the Honorable Supreme Court in very recent judgment, this is 17 days prior, that's why very recent. On 11th August, held that only BEd candidates are eligible for appointment of post of assistant teacher, and inclusion of BEd is legal, what notification dated 23rd August. And accordingly, rules of state of Chhattisgarh regarding inclusion of BEd has also to be held as unlawful. Therefore, pray for staying the further recruitment process at the final disposal of the petition, etc. And then considering the arguments advanced, and they make a reference to Devesh Sharma at the bottom of the page, the further recruitment process shall be kept in arrears with immediate effect, and further no final decision will be taken. Right now? Now against this, they come in SLP before your lunch. That is at page 591 and 592 on 29th August 2023. At 592. Your Lordships note after noting the CA 5068 in the second paragraph, the 592 bottom paragraph, therefore, to the said extent, we hereby say the order in passed the High Court and clarified that the recruitment process which was in progress prior to the date of interim order can continue, and the appointments, if any, made thereunder will, however, remain subject to the result of consideration to be made by the High Court in petitions also. So your Lordship make it unequal here that this will be subject to the interim order. And the interim order has come. They are abided by the consequences of it. There's yet another reason why they have to abide by the consequences. And now the shoe is on the other foot. That clarity. Show you okay, further on, page 651, at bottom of 651. Page 651, and this at 651, this is the A paper.
As it appears.
Last three lines, yes, as it appears, that large number have already been appointed on the basis of eligibility criteria, etc. We do not think it equitable to effect the removal. We accordingly hold that the judgment in so and so shall have prospective operation. But prospective operation of this judgment shall be only for those candidates who are appointed without any qualification or conditions imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have been instituted by them, and such candidates were in regular employment without any disqualification. Now you have to be in regular employment. They were clearly not in regular employment also on that date, on 11/8/2023. That is very unequivocally what your worships have said. On 11/8/2023, they were being told by the High Court that this recruitment process is being halted. They came to the Supreme Court, and the Supreme Court said that look, it can continue subject to the outcome. Now the outcome has come. That this makes it clear they should have been in regular appointment on that day. So the next sentence you say, we make it clear that this benefit is only for the candidates who were appointed prior to the date our judgment was delivered on August 2023. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under the present order, which is the benefit they are seeking today. They are seeking a review of this order, and they are saying mere selection should benefit me, so please give me the appointment which I am not permitted to get under either this order or the principal judgment bench. The appointment letter which was issued to them at page 594 records this. So they are abundantly put on notice about each of these. So page 94 blocks. Now, page 594 is the appointment order, which notes first, this is one of the appointment orders, it's 29 September. The about 4 lines from the bottom at 594. This is the term, and then and you go there. Yes. 4 lines from the bottom. it says last three line, initiation of document was made from 8/9/23 to date 13/9/20. This is also after the cutoff dates to show. The whole counseling process started only from 8 September. There is the resolution, the transmission.
Observable content is in this.
In the both documents
SLP and
SLP refers to appointment order and reference file which is the one on the which you. So both are added and then even the appointment letter makes it clear.
Another SLP before the Supreme Court.
And SLP diary number, what's the diary number? You can
592 days were
okay. The diary number 3532 on the bits that interim order pay. Supreme Court.
592.
Yes.
780.
That's a subject of. Now, if you see this appointment, it's in September of 23. The impugned judgment is in 8 days, barely 6 months. That's all it is. So they have barely started off in the probation period, and now they're making a song and dance about the fact that look, we are being recruited, we have been there in the saddle for so long. And this is not one of those cases. I can understand hard cases where you have been 7 years in courts, etc. Barely 6 months, you had an interim order. The Supreme Court put you on notice, the High Court put you on notice, your appointment order puts you on notice. So this is perhaps not the kind of case where they should be making this shindig about it. This is where you must, I think, gracefully exit, as similarly circumstanced people have done in.
And it would be understood.
Yeah. Not that. Now, one additional point regarding the. Judgment in Devesh Sharma starts at page 520. I just wanted your lordship to see two specific things which are paragraphs 5 and 10. Page 5. Page number is 524.
That a file level. PDF never works.
It's not PDF 560, is it? 560.
Which page you are referring to?
So page 524. Para 5.
Yes, sir.
Para 5 and 10 I want to show you. Para 5, out of the 3 writ petitions, because apart from the SLPs from Rajasthan, there were these writ petitions. Out of the 3 writ petitions before us, 2 are challenging the notification dated so and so, and the subsequent notification issued by the governments of Bihar and UP, typically calling for application from eligible candidates. So, is against an interim order of Calcutta High Court. So, West Bengal, Bihar, UP. Now, your lordships were aware of the fact that these disputes were going on in various states. So, see please, para 10. Next page, 526. During the course of hearing, at 10. During the course of hearing, this court had passed an order dated 24th August 22, granting liberty to the Board of Secondary Education for different states and other stakeholders to be included as interveners. Pursuant to this order, several interlocutory applications were filed, which are being heard along with these appeals. So now, if they choose not to come, either the state or any of the other petitioners before your lordship, when they are aware that the very same notification, very same qualification is up and being examined, and your lordship have gone out of the name, ask please come. If any of you want to file intervention, many people did. Many individuals filed intervention. Ms. Grover was there. Ms. Agarwal was there, and she had argued this case. So many states, many other individuals, etc., had all been there and they've taken part in these proceedings. So for them to say that, look, this took place somehow we can have that, that is different kind of opportunity. Again, you know, to recall when the Madhya Pradesh application was moved, which was also treated as a regular part of the order. There were other states present, and some other states also present. So I think it's too late in the day for them now to say that, look, Devesh Sharma actually took place in the dark, and we were not privy to that. One further thing, we have RTI responses which show us that there is no such bridge course in the state of. That is the first thing. You know, this date of action. This is to NCTE. You know, the NCTE is required to set up the bridge course. The application. So instead,
Also done for that, and in some cases it has been done by some open universities and
yes, but that's not recognized. It needs to be recognized.
there is a problem.
So section 23 is.
That non-self status for 6 months.
I didn't interrupt my friend. I'm sure.
Clarify.
You don't need to clarify, I'm sure, right? So the response is dated 14th July 21, and the reply, which is the 7th column there, says, the norms and standards for 6 months this course has not been drafted so far. Now, one thing is particular unequal. 21. Take up 21. He had to say the applicant has handed over my friend, he has come 30. He had to have to come 30. He said, we have a bridge course. In 2021, they don't have bridge course.
Forget the bridge, because there is no bridge also.
There's no bridge. Really, that's also. I mean, that's behind materials. That's really important.
This collapse.
So,
States there are great deals of collapse in the business.
if the lordship in fact sees section 23 of the RTE Act, it is unequivocal that it is only the specified authority which is which can lay down the qualification. Relaxations in that under 22 can only be by the central government. State government has absolutely no. So they can't set up bridge course of their own and say we have a bridge course, if at all that is their argument. No.
It is not, you can't call it a sham in that sense, because,
Yes.
see, when this judgment was being argued, in this case was argued, judgment was written,
Yes.
there is all the documents, you know.
Yes. No,
It's over to argue, and then it's over. The difficulty starts there.
that's true. No, but your lordships are in fact extract revenue matters.
When they are going to file,
Yes.
there is a correspondence which says that there is a bridge course.
Yes.
Central government, you know, it's basically central government baby.
Correct.
They wanted to push it because the central school wanted it for some reason.
Correct.
And there it is said the bridge in many courses, bridge courses, some module has been prepared,
Yes.
underway, there was something like that.
Yes.
But then this is the bridge course.
Correct.
But the idea was that in the next education policy, they are coming up with a combined 5-year course.
Yes.
If that comes in, then this BA and LT, there is no problem there.
So they came out with the National Education Policy in 2020, which specifically provided for that so-called 5-year plan.
There is just a mention, nothing has happened.
Nothing
It's a
happened.
policy.
Still not been implemented. Till date. In fact, your lordship were conscious of this, so when you gave your findings eventually and said that it is arbitrary to bring in a BA course, you also made one further observation which is critical, which is that it is not that the BA is a higher standard. The lordship says, given the
Yeah, it's
conclusion,
a qualification.
the only logic given by the central government to include BA as a qualification is that it is a higher qualification. This we have already seen is not correct. But that is precisely the argument being made by the state just now. Mr. Nagraj said it is a a higher qualification. So using the motor vehicles judgment, the 1994 motor vehicles judgment, he relied on that to say states can provide higher norms, higher standards. Don't you recall just before that he handed up the 94 judgment. It was for that. To say that therefore states can evolve higher standards, etc. But your logic to say it's not a higher standard. So even that tiny avenue which is available to try and somehow protect them, I don't think that either stands. But so I don't believe notice shouldn't be entertained at this stage. That's all I have to say. We want to take a lordship through the background. I'm grateful.
But my learning to be has covered much of that. I won't be doing. And it's just one thing that if I may, I don't think I can. I may just put it on very distinct, separate, very brief points. My lords put that question just now on the bridge course, but my lords may recollect when the judgment in the case to which was debated, that bridge course thing comes from section 23 of the RTC. They said, if you have a shortage of teachers, one not qualified, you may take them in subject. And that was only an ad interim arrangement. Therefore, the primary argument in the debate was that when you have these candidates available who are actually qualified, us, why would we select candidates who would still have to take the bridge course, for whom there was only an interim arrangement made under the RTE Act? So, my lords, today, I would respectfully submit it's the same situation. There are a large number of female candidates, far larger than the number of vacancies that are there that have been advertised, who have today been ousted, replaced by BEd, who are actually not qualified and who are occupying the positions when these people should be rightly occupying them. The other ground that has been urged is on the equity. While also far as job opportunities are concerned, they equally apply to those who are out and trying to get in, or for those who have gone in but are not qualified.
No, but suppose now what will happen is,
Please,
these are the person who are already on the job.
please,
Now, if suppose we say nothing, you are not qualified, you go. How will that benefit you?
Well, it benefits us because immediately those 3,000 or 2,600, I don't know exactly, because they said 2,600 and others said 3,500, they get vacated, and those of us who are high up on the merit will immediately occupy those positions.
That's the thing.
That's the position how it will work out. So, my lords, it is actually hard. It may be hard for them, but it is equally hard for us. Number two, there would be enough number of BEd vacancies that would be available in the state for the higher education, and my lords can mold the relief they get rightly in the qualified jobs. Whether it is an age relaxation, whatever, my lords can mold that relief for them, so that they qualify for whatever in their areas, we can mold them to qualify.
Whether these candidates can be accommodated. Whether they can be accommodated for class 6, 7 and 8.
Yes, sir. My lords, that's what the state will do, they can be done. But my lords, we don't qualify them. We are only from 1 to 5.
There is a problem there also. 7, 8, if they go there, then there is people there in 6, 7, 8 also.
Vacancies, there will be vacancies. They have said that 27,000 vacancies. We are only.
It's always going to be a problem. Because if we say, okay, consider that the 6, 7, 8, then it can be done by 2 ways. Either the present vacancies are to be done, then somebody has to be moved, I don't know. But if it has to go beyond the, whatever the people must have been already filled for 6, 7, 8.
My lords,
27,000 that list that
27,000 in all.
Yes, it's bigger today. So
These are not vacancies. Someone after a year or something. It should not be advertised. I mean, if the candidate waiting period 1, 6, 7, 8, yes, you can't put somebody only.
So that's what happened to us.
No. Now, with the.
would put it only on this side, that we can only be for class 1 to 5. We have no opportunities for 6 onwards till the 12. They are qualified for that.
We have to think about that also. No? Sometimes instead of bringing a solution, we create more problems. We don't want to get into that.
Very good. I'll leave that there. So, my lords, I say in terms of equities, we are as much in hardship as others. The second thing that I would implore your lordship to consider is this. My lords, all persons who have been affected by this set of proceedings regarding the NCTE's letter of 28th of June, based on that minister's letter, which was that notification across India, they have been relegated or they have to go out in other states, the BA 10. Now, treating similarly situated people, maybe because of a fortuitous circumstance, that one is in Bihar, other is in Uttarakhand, goes out, but the one in Chhattisgarh stays in, not do justice to people who are all identically similarly situated. Because, my lord, the common underlying factor on each one of these cases is the notification of NCTE. And yes, please, my lord. So, my lords, having said that, I would say one thing, that right from 25th November 2021, across everywhere, people were aware that the NCTE notification of 28th June 2018 had been struck down by Rajasthan High Court. What was carried before my lord upheld that judgment. So the quashing, in fact, if I may say so, took place on 25th November 2021. Be that as it may, my lords have clarified and said those appointed prior to the date of my lord's judgment, that's all right.
25th November 21 the Rajasthan.
2021 is the Rajasthan High Court judgment.
25th November.
November 2021, and my lords did not say that. So all the states in the country were aware, and my lords, this was a central government notification under the NCTE Act. So therefore, once the central government notification is struck down by any high court, it is for all effects and purposes struck down. So it's not that it is valid in one state and not valid in the other, because it's a central notification. Now, my lords, I put all that aside for a minute and point out that when my lords pronounced on 11th of August 2023 the judgment, and my lords have today clarified that to be a cut-off date, the NCTE, by a communication on 4th of September 2023, it informed all the states that pronounced the judgment, and the same is now right? That is to the government. My lord, this is here to the government of Chhattisgarh. Now, I would ask myself the question, my lords, where is the question of making an appointment much thereafter, as on 29th of September 2023. My lord, this is, the state government was aware, the communication had been said, today much has been said, we didn't participate, we didn't know. My learned friend.
This is a communication which is being given by the NCTE is an academic authority.
Yes.
This has a lot of weight.
Yes,
Go
sir.
down, go down, go down. And it says now it's a judgment, you follow it.
Yes.
But there is a twist to the story. And the twist is that you file a petition there is a Supreme Court judgment and they say midway they stop it. They come here and they get an interim order, they get an order from this court that the process will go on. And on the strength of that Supreme Court order, they get their appointment.
So,
Who will be higher than this?
my lords,
Anybody
the
can see
state should have disclosed it, but I put it aside for a moment. For that,
They might be on medium, you see, but they will always take a shield of that thing and
yes. But that.
they have a reason.
My lords, I think we can break that shield here and now,
Ah.
and that I say so because of my lords. April 2024, my lord said that if there is any petition on that word, why then here fits in completely. Because in the Supreme Court, when the condition was imposed that their appointments will be subject to the outcome of a writ petition, the SLP was filed by them. That SLP was filed by them. Because now, my lords on 8th of
Exactly, go on.
subject to the outcome of the writ petition pending in the High Court. So my lord said, why then? Different state, and with that they have taken this express argument of the Ramcharan Maurya judgment as the very first round, and that review was dismissed. Apart from the fact that I have a distinct recollection that when this matter was being argued before my lord, Ramcharan Maurya was cited before my lord, but it was pointed out by us to my lord that Ramcharan Maurya had that paragraph in it which specifically said that there was no challenge to that particular notification of 28th June 2018 in the Ramcharan Maurya case. Yes. So my lords, we had shown those paragraphs to my lords at that time. But having said that, because it does not appear there, a review came to be filed. Now in that review, the first round taken is Ramcharan Maurya, and that has been dismissed. So my lords, therefore, no, it was argued. I heard that argument before I had to go for it.
Review was filed by somebody from Rajasthan.
No, but Ramcharan was argued when the main petition.
Main matter, so
On that, somebody may, because argument can be said because the doctrine don't notice that in the judgment.
Judgment it is.
Judgment does not contain that judgment of Ramcharan Maurya. So therefore, somebody can say that you have not considered that judgment. But I am not, we have not argued on that at all, Vinod here.
What is the citation of Ramcharan?
It's next year, it's 770. It's to 2021, volume 15 SCC.
Yeah, next the entire judgment.
That judgment is annexed in this SLT also.
Not page 158, in my SLP, Naveen Kumar, 158 of my SLP,
And I can show
What?
lots of
that
paragraphs.
whole judgment, Vinod, as reported in volume 1, is there.
This is the red.
Yes. And my
No,
lord,
I am not saying, that's what.
I am confused.
That's all, no, because we are not saying it. We are not saying it.
Confused.
We are not saying it. You know, Something
Abuse
cited at the bar.
Let me show that.
My friend said that she also cited it.
Now,
Just now she said.
Rajiv Kumar,
That's remember having gone.
That's all right.
we are Rajiv Kumar.
We are not arguing it.
Very well, if I am not arguing it, I need not show you the review and the fact that review taking the specific ground has been. There are other grounds also which has been specifically dismissed. Now, my lords, I would submit this, that for various other states, in very identical facts, my lords have rejected similar applications. My lords, I would submit that people have to be treated equally. That's also an equity. By a fortuitous circumstance, somebody enters and which is subject to the outcome of a writ, they cannot turn around and take a benefit of that, which, my lords, I am repeating myself, but is also coupled with the orders that have been passed by my lords. Now, my lords, the writ petition before the court is being filed prior to Divesh Sharma. Please, my lords, will find that it is filed on 30th of May 2023. It's before.
Chhattisgarh.
Yes, my lord. It was being challenging the notification and the rules, and the rule in particular. It was thought to be suggested during the argument that it has been filed after the date. That's completely incorrect. My lords will find this at page 1 minute now. Page 472 and 473. The date of filing of the petition before the High Court was 30th of May 2023, and the prayer challenging the rule is at page number 511. But my lords, I may have challenged that particular rule and there is a judgment in my favor. Please see at page 511. It is 10.2, which is the challenge to the rule at 511. Now, my lords, we putting this aside, I will only say this, that the state government, even under the rules, for the purpose of appointment, it is mandated to meet with the educational qualification prescribed by NCTE. Now, if the educational qualification prescribed by NCTE, as has been held by my lords, to be BEd for the primary and BEd for the later, then even the rules of those appointments, qualifications are bound by that. So whether there was a challenge, but whether there was a challenge or not, once the instructing notification of NCTE dated 28/6/2018 was quashed, it was clear that no state page number 33 of the improved judgment. My lords, we have brought to this of the High Court of similar matters, medical matters which had been withdrawn after, and they have all been listed in this particular judgment of the High Court. The High Court takes note of the fact that there were similar matters which came to be filed and they had been withdrawn, and my lords had confirmed my lord's judgment subsequently. Now, my lords, at page number 36 is the Uttarakhand High Court judgment, which again is Mal versus Union of India, which came to be confirmed by this honorable court. My lords, the extract of that judgment is at page 37. If my lords may just give me a minute of that. My lords have that. It starts at page 36 bottom. So my lord, similar thing came up in Uttarakhand, and the Uttarakhand High Court then passed this order since the issue has been decided by Honorable Supreme Court. Present petition is disposed of in that judgment. Then my lord, the MA came to be filed before this court asking for modification or clarification of my lord's order. The next paragraph itself. And then my lords, that all came to be rejected by my lords. My lords, page number 52, the High Court notices the argument that the Rajasthan High Court judgment was of 25th of November 2021. And because it was under the RTE Act, the central legislation, this was being struck down, it applied across. So the court took the view that applying the judgment of Kusum Ingalls, which was sought to be applied, once it is quashed, has an overriding effect and would apply across to everyone. So for the, my lords will find that particular part being dealt with at page number 52. Would my lords like to see that part?
Yeah, we have 52 with us.
Yes. Rule 8.3 of the rules prescribe for qualification of teachers for appointment in primary school, which speaks of applicability of a prescription of qualification under the RTE Act 2009 as mutatis mutandis in Rule of 2090, which is what they want to rely on. The state has committed an illegality by permitting candidates having qualification of year in selection process initiated by advertisement dated 4/5/19. Now, since the said qualification does not exist in the statute book of RTE Act 2009, after its quashment by Rajasthan High Court, 25th of November 2021, when I was fined, then the law is well settled in Kusum Ingalls that once a central statute is quashed by one of the High Court, it would be applicable to all states subject to its applicability.
What is this subject to its applicability?
My lords, if there is a provision in the statutes that the states can modify or states can change them, the power is there. For example, if it is something in the list 3, then maybe the central may issue something, but the state can modify. But when it is covered only by a statute in respect of which a state cannot modify at all, then my lords, once it's quashed by one High Court, it applies across for everyone. This was the argument, my lord.
Yeah.
The RTE Act being a central act having overriding effect by virtue of Article 254 of the Constitution and with the provision in the present section 23 of the Act is quashed or declared ultra vires, it would then it would not be applicable to the other states. Yes, the quantum will be applicable. State of Chhattisgarh has clearly committed an error in keeping the provision regarding the prescription of qualification of B.Ed alive in the rules in 2019, even after the improved judgment of Rajasthan High Court. My lords have upheld this caution in my lord's judgment, and after upholding it, because there were also writs before my lords went on to say that notification dated 28 June is quashed. It reiterates that position. But then on 8th of April, my lords have taken a view, it's all right, we abide by that view. My lords, here, it does not meet with anything. It does not meet with the date of an appointment, which my lords put, which is after 8th of August 2023. It does not satisfy the test of my lords, even in the case that because there is a condition that is imposed on their appointment, it does not meet with that. They have been appointed well after 8th of August, my lords, 2023. My lords, lastly, as my learned friend says, that my lords, by a 3-judge bench order, which is enclosed, I have filed it in Bhagwan Krishna's case, following my first judgment, have actually rejected the petition that had come in that case, I think from the state of Bihar. And they have clearly said that it would all consequent advertisements and all steps taken pursuant thereto were invalid. My lords, can I just show you this one order and I rest it there?
Page?
My lords,
588.
page number 588.
This is Bhagwan Krishna.
Yes.
Yeah,
So, my lords, this was identical matter. This was a 32 which was invoked by lords. And this, and Union of India, the party, please come to the third page 589. The page bottom of 588 records the quashing and then come to 589. The present petition stands allowed in terms of prayer A to the extent the same relates to notification issued by NCTE on 28/6/2018. Consequential advertisement and other subsequent steps taken pursuant thereof shall also stand invalidated. State of Bihar, now Bihar was not a party here, is not a party before this court in this petition. As such, we make no comments regarding the notifications issued by State of Bihar, the legality of which have been challenged in this writ petition. But this court expects the State of Bihar shall take into account the judgment delivered on 11/8/2023. And when also therefore everything done consequent to the notification of 28/6/2018, my lords have quashed it and invalidated it. And when also the present appointments are all appropriate consequent to the notification of 28/6/2018. My lords, I would therefore submit that this is not a matter that my lords merits my lords consideration. It ought to be dismissed at this stage. My lords, these people have filed their writ petitions way back in 23. They have qualified. They are waiting for their appointments. My lords, job is equally important for everyone across board. They are not qualified. They are not eligible. As against we people who are all qualified and succeed on all counts. Unbelievable.
But I have this one sentence to add, which is that the lordships recall that when we argued that application, the 8th April 24, your clarification matter where you let to pass order on prospectivity and retrospective, one of the arguments we had taken was actually the cutoff date should be the Rajasthan High Court judgment. When your lordships were balancing it, eventually you had the Devish to be the cutoff date. Now, obviously, that contemplates a scenario. Somebody who is from the BN who has been appointed will lose his job. That's the idea behind making it prospective. If these petitions were to succeed, it entirely frustrates the question and it is not be retrospective, it will also not be prospective because these are appointments which took place after that. There is bound to be, I can sense this hard work from Justice Dulia particularly, there is bound to be situations where the end have been appointed. There's bound to be those situations where they will come and say, look, save us. But unfortunately, the sharp end of the wedge has to come down. And 8th April makes it clear that it does come down in this fashion. So if you are appointed after this date, I'm afraid but you makes it. You have the benefits of 6 months of employment and wages, etc. etc. But now you are doing it. Agreed.
Want to say something in Vijayendra?
Yes, permit me. But first of all, this chart about the states, but I have just taken instruction. So I will just inform your lordship.
Which one?
The chart of the different states. So I am only answering each one of them, because I have just taken instructions from them. The first plot, so far as Rajasthan is concerned, that goes without saying, 11th August. And in the Rajasthan matter, there was a review petition filed, which was dismissed, by some B.Ed candidate, and there, no B.Ed candidate was even allowed to participate. Because the advertisement, as you lordship recall, never even asked B.Ed to apply. Now, insofar as Bihar is concerned, insofar as the first order, which is by DLA, 28/8/2023 order, the state directed to follow Devesh Sharma, and in terms of that Bhagwan Krishna, the 3-judge bench order, which my friend just now read, state directed to follow Devesh Sharma advertisement not caused, but steps taken in pursuance of NCTE notification invalidated. Now, thereafter, what happened that all persons there, what had been appointed before that date of 11/8/2023. So a review has been filed in terms of your lordship's clarification order of 8/4/2024, which review is pending before the Patna High Court, that your lordships have validated those who were appointed before 11/8/2023. So nobody has been appointed in Bihar after 11/8/2023. Nobody. In terms of no B.Ed has been appointed. Let me put it clearly. So therefore, this state of Bihar SLP dismissal, etc. Now this dismissal, which is the first one, 9/10/23, by people who were seeking appointment. B.Ed people seeking appointment after 11. So that is the position about all these two, my lord. Your lordship, my friend has rightly written their B.Ed candidate, one is state of PR, one is B.Ed, so both were dismissed, my lord. That we can't give to B.Ed. Insofar as Chhattisgarh is concerned, my lord, we are here before your lordship. Insofar as West Bengal is concerned, this was dismissed. This is also covered by the order, my lord, because of they were all prior to 2020. Insofar as Madhya Pradesh is concerned, so therefore that was not saved, only not made of the outcome, and the MA was would come here. I needed to clarify the factual situation regarding this. Chhattisgarh, everybody else where B.Ed came for appointment, they were not granted. In Chhattisgarh, B.Ed have been appointed before and after, whatever, because the 2019 notification was also there for advertisement, there people were appointed. Subsequently, in our case, though we are appointed, the date of appointment letter is later, but we are appointed. It is only in Chhattisgarh where it will be paused. It has not been paused in any other state. In my instruction, that B.Ed appointed, their appointment paused because they were appointed after 11 and 20. So in that is the uniqueness. That's why in the beginning we had said Chhattisgarh is a known case. And your third point, Lord, with respect to what I say, is that Lord, let us look at it from an angle. Supposing Lord that 2018 notification was not there at all, I ask myself, would the state government in the 2019 rules have prescribed B.Ed as being eligible? I ask myself this question. And if it had been done, and the judgment of Devesh Sharma deholds the notification of 28/6/18, the High Court could come to a conclusion, as my Lord did, of course, not in Devesh Sharma, but I am not joining issue on that no, B.Ed is not the correct qualification, it cannot be included. It would have been paused the way it is done today, and that would have happened on 2nd April 2024. So that would be subsequent to the appointment order. So I am respectfully respectfully submitting that looking at the challenge to the rules of 30th May made by them in the petition of 30th May, which are ultimately culminated in a judgment, and your lordship's last part of the order in para 36, which my friend Mr. Srivastava read, and the last part of that Manipur judgment of 3-judge bench, which your lordship said unless the statute is struck down, till it is struck down. The statute here is struck down only on 2/4/2024. As I respectfully pointed out earlier. So now 3 pages which my friend showed, I need to show you. Page 152, where page 152, just 3 pages, no more than that. 152. For teacher, classes 6 to 8 or
Rules are of which year?
these rules are of 2019, March 2019. 5th March 2019, they were made for the first time.
After the NCTE notification.
Yes, yeah, of course, I don't say otherwise. But they came there, the rules were promulgated for the first time, for everything.
That there were no rules.
No, they were, this is also it also includes the promotion rules, recruitment and promotion. There were different sources of recruitment, by direct recruitment, by promotion, by transfer and deputation, by absorption.
Prior to that, there were no rules.
There may have been some rules of Madhya Pradesh, which may be continuing,
As per the reorganization order, they were continuing.
They would be continuing. They would be continuing, The repeal and savings,
So they took a long time.
maybe,
19 years to check.
Quite so. Because the rule were. They have continued. Section rule 22 of these rules, at page 136 shows all the rules corresponding to the rules that are enforced immediately before the commencement are hereby repealed. So they don't point out that which are the rules they are repealed. So anything which was enforced, that those enforced would be only Madhya Pradesh rules, but not in my understanding. So that's very what to say about that.
I have been just instructed, the council is and they this. There were rules, not one was 2012. What happened, that the appointment to these schools were, it's in the hands of the panchayats, something. So, the right of that 2019 rules were.
Yeah. You're right, Panchayat. Because there was a judgment, there was a difference of opinion also.
Yes, not the Lordship is the very correct.
This is Vishwanath there, it's Maheshwari.
Yes, that's exactly that.
There were Panchayat rules and all.
That's how it happened.
Ah,
That's what I said, there was a void, there was a vacuum.
It can't be,
Can't be like that. Or in any case, before that, under the provisions of the law of the Act, will not be.
The organization had said, I have not read this reorganization. I just say all this. They said within 1 year or 2 years you can do that.
But so that is not the modification within
Modification.
years. If that is not made, then not the rules are continuing. That's how.
152 is what I wanted to draw attention. My friend said, that the DLE, the elementary education diploma, is only for assistant teacher, that may not correct if your lordship is teacher. The first entry number A, in the middle of the page, graduation and 2-year diploma in elementary education. So it's not that they were not qualified for 6 to 8. That is one. Secondly, in answer to this also, I wanted to say this respectfully, that so far as these rules are concerned, everybody applied for all the three. And it is not mentioned by them that what was their rank. Their rank, my friend who say that 1 lakh of us are available. Next recruitment you can apply. Available does not mean that you have been declared successful. The lordships have seen the last mark at 1,46,000 is -20 also mark, because there was negative marking also. So for my friends to say that 1 lakh of us are having this diploma in elementary education and are available. Available, yes, of course. Available, many people can apply because.
Why negative? Must
be
negative.
Negative marking. There was negative marking also. So that's one page. The second page I wanted to show was 527. My friends relied upon that your lordship said anybody who wants to have can have liberty to apply. Your lordship did not, with respect and all humility I say, did not issue notice to all the states. In many matters, your lordship, when your lordship feel an apparent problem, that your lordship issue notice to all the states or all the advocate general or the attorney general, but something like that. Here, what was reserved in this para at 527 is this lot, the 526.
There was no constitutional provision which was to be.
Quite so, but notice could go to the state, because what your lordship said, granting liberty to the Board of Secondary Education for different states. Now, whether this order, not this para of liberty of 1824-822 reached all the boards is a question. Whether it reached or it did not reach, we do not know. Then we got 6, and the Chhattisgarh, the board did not come here. Let me put it that way. Then 652, what my friend pointed out. If you watch it, see 652, which is that order of clarification dated 8th April. This part about the bridge course, this bridge course is conducted there as my friend Mr. Tiwari has already handed over by the
Item 9 was asked the question.
No, just this last time, no more to
We have some fresh matters.
Oh, I'm sorry. I'm just sorry. One sentence more and nothing more. If Lordship just see, the 652 where Lordship said everybody will have to undergo bridge course here. And my friend Mr. Tiwari handed over a 2017 paper. This bridge course was being conducted by the NIOS, National Institute of Open Schooling, which is a right body under the NCTE, and therefore not that bridge course was being conducted, and that is what my friend also handed over the curriculum of that curriculum. And the RTI only said that the norms and standards for the bridge course have not been drafted. Norms and standards have not been. That does not mean because the bridge course was not going. Norm not being drafted. The curriculum was fixed and NIS was doing NIOS. So therefore, I just wanted to answer that part. I'm much obliged, very grateful. I didn't want to take more than that.
Good, sir. Yeah, I'll be very, very brief, honestly. But there is only one point, Lord, which I think I should assist you, Lord. Lord, I begin my submission, Lord, that I am proceeding on the basis. Judgment. That's how the Lord I began. And Para 36, the Lord is an integral part of the judgment, the Lord, your Lordship will come with us. That this way, the Lord, the prospective, the Lord, in effect, in the sense that those who were on the date of the advertisement were holding the qualification of PA, they will not be a student. So, for that purpose, the date of advertisement becomes a crucial date. Now, what we are submitting, the Lord, is at the end of this 5 hours, the Lord's long hearing around, we are all indeed very much grateful to your Lordship for patience. That every day they made out the case. Justice because your Lordship will certainly technicable jurisdiction under the Article 136, the Lords. Have we made out the case, the Lord, for justice, tampered with compassion in our favor or not? Tampered with compassion.
Tampered with compassion.
Only trying to not say other way of saying, the Lord, that you are asking for, what's it?
The law is law. It may be harsh.
Correct, Lord, but sometimes equity is
that Devashish is the correct law. There is nothing wrong in the judgment of the High Court. Only the equities have to be balanced.
That's correct, Lord. So now, Lord, the other thing is this, Lord, what is the cut-off date, Lord? That's the only serious point which I wish to have.
Has been mentioned in the judgment of the Supreme Court.
Yes.
So,
How does just 2 minutes if they will tell you just
Yes.
now?
Yes, Lord.
There. all challenge the order of the Chhattisgarh High Court.
Sir, it's only Chhattisgarh High Court. No other state members. No other state.
10 and 11.
Added to item 8. To be taken along with it. To 10, 11 plus 8 to 8.6.
6.
So there is it. Third,
First, can I speak to the Lordship doesn't have Well, there's an important aspect where I think your Lordships must be assisted by me on that aspect. Well, I'm reading your Lordships need not open the brief Lords once again, Lords, but I'm reading the last concluding paragraph, which is the operative part of the High Court's judgment. Lord, what does it say? Please have it, Lords. In my SLP, it is page 56. Para 39. It's the last operative part.
last,
Operative. Please, and to decide what is the formation. The regulations is to be allowed by declaring the prescription of need as eligible qualification for the course of assistant teachers. So it's a declaration which takes place by this judgment, that it is PA. As illegal, it is different from the state of the judgment, 2nd April 2023. So therefore, for the purposes of para 36 of the Lordship judgment, Lords, this declaration having taken place only on 2nd April 2023 by this 24 by this impugned judgment of High Court, my Lords. The date, my Lords, I am not using the expression cut off date or other expression. The issue has been closed, not subject to Lordships final order only on 2nd April 2024. Why? The reason is this, my Lord, there are three Lords states which are very important.
2nd April.
2024, the High Court judgment date, impugned judgment date. That's an element. Reason is this. 11th August 2023. There is a Supreme Court judgment, the Lord's Lordship judgment. The most important the intervention in between is the order of this Honorable Court dated 29/8/2023 in Chhattisgarh State that we say that the High Court is required to decide the manner in which your Lordship's judgment is required to be constituted, that is with regard to the perspective. The effect of this order is this.
The argument which you were making initially.
Yes, no, just I'm saying, add one thing. So, my Lord, the question, my Lord, was not closed so far as we are concerned by David Sharma.
And High Court didn't consider it in the light which is output.
Yes. So, 29th August 2023 order kept the issue alive till it was finally decided by the 2nd April. 2nd April, that's my submission. And there was, with regard to the clarification order, the Lords, I am just saying that we are not party, we have not been heard, the Lords. And in any case, it's a clarification order, it is not an order in the Lords. It only binds the parties, inter parties. But the clarification order will not dilute the Lord's main judgment in para 36. That's all I want to say, Lords. And as far as the state, the number of vacancies, rearrangement, etc. is concerned, because the final relief is, which is given by the High Court after declaration is that you rearrange the list, and the state government should rearrange the list, exclude here. If it is possible to rearrange the list in a manner that we are not required to be excluded, and as I conceded, the Lords, that we are ready to be placed at the bottom of the list, please do not protect us. That's all I'm saying.
All these petitions are a challenge to the High Court's order dated sitting the comparative people. Stop. All the rest, what the group, all the rest is the environment of people. This order in turn follow. They were recognized this group. In Vivad Sharma Solution, along with Vivad Sharma, there are others, case in all the councils, petitioners, as well as the council for the respondent, that's led, we find absolutely no merit in these petitions of this The reasons will follow, we get some detailed reasons.
We are discussing that.
But, sorry, just one small thing, in these very matters, your Lordship said past two previous order, one dated 3rd July 24, and the second dated 15th July 24, in both of which you have said that the impugned judgment may be implemented immediately. That's not happening from observation that it may be implemented.
My boss didn't grant a stay and said the judgment should be implemented, and yet despite those orders passed.
No, you're not
Here now they have to be implemented.
Since then I started saying that implemented, bound to be implemented.
It's just timeline.
But they are fine, a contempt in the High Court, that what they suppose, therefore they are saying this.
We can't be policemen in this.
No, but it's not timeline. I'm grateful. Very
और
good.
ये काम है हमने कर दिया बात है.
That's it. Very good.
Pressure.